Welcome to Looking at Legal Stuff. Today we have 3 hearings, including 2 earlier ones that were missing, to see if the final divorce decree has been signed by the soon-to-be ex-husband. He says he's willing to sign it, but he wants to make a statement to the court first. The judge tells him he's not interested in hearing any statements, but the bitter husband can't seem to control himself and tells the world anyway. He claims his wife committed adultery and sold herself, and accuses her of destroying their family. He claims he's too broke to come and sign in person, as he isn't getting any child support, and he wants to know if the divorce will be done before Valentine's Day. Let's watch.
Okay, so this is now 2023-2641 DM. Trisha Rice versus James Rice. It is Monday, December 4th, 2023 at 1:29 p.m. Attorney Ryan Buckland for plaintiff.
Okay. Good afternoon to everyone.
Good afternoon.
Mr. Rice, what we're doing, this is a scheduling conference, and we're going to put into place various dates and processes that would make the case proceed in an orderly fashion. As Mr. Buckland represents the plaintiff, I'll go to him first, then I'll get input from you at that point. So, Mr. Buckland, what do you believe to be the issues in dispute in this case?
I would expect, Judge, they're going to be fairly limited. I would say that the child that's listed in the pleadings, I believe he turns 18 in 11 days, so that should resolve any custody support parenting time issues in that regard. And then with regard to property, I believe that the marital residence that Mr. Rice is living in may be in the trust of his parents. And so I would just basically want some verification that that is the case. Outside of that, I think we're just going to have a few pieces of personal property that we just need to sort through, and that I think would take care of it.
Okay. Mr. Rice, what's your thoughts as it relates to the issues in dispute?
If that's all she wants, that's fine. Nothing. My house is in a trust. I got a rent-free lease for life, or whatever you want to call it. I get to live here rent-free for life. And I have no assets. I have no money. I work for a neighbor for about $100 a week. My only concern is if he wants to try and get me for half her credit card bills, I'm going to have a real issue with that, and I'm going to bring up a lot of past things. And that's the only question. If they don't try to hit me for credit cards that I had nothing to do with, I agree to everything.
Okay. Well, what we'll do, Mr. Buckland, what if we adjourn this matter for about 30 days, give you a chance to get the information you need, and then at that point we can get back, and if we are not resolved by that point, then we'll do a scheduling order and make the matter proceed as a contested matter.
Sure.
So, Mr. Rice, you stated that you're in the house based on a trust, and Mr. Buckland obviously is going to want to get confirmation of that. So if you can send some
I'm pretty sure my wife already gave him one.
Mr. Buckland, do you have one of those?
I do not.
Okay. Mr. Rice,
Okay.
why don't you send it to him? That'll help expedite getting the matter resolved.
Absolutely.
And then we'll be back in about 30 days and see where we're at.
Sounds good.
Okay.
Thank you, Judge.
Thank you.
Am I going to get some kind of mail or I mean, are you going to mail me some kind of thing?
We'll send you another notice for about 30 days from now for a rescheduled scheduling conference, and see if that's necessary at that point. If we haven't resolved things by that point, then we'll have it proceed as a contested matter.
All right. As long as I don't have paid credit cards, that's fine. Everything's fine.
You can talk to Mr. Buckland about that. The court's not involved in that at this point. So
I didn't even know if I could talk to him.
well, you can talk to him. Yep.
Oh, okay.
Okay. Thank you. Have a good day. You're free to go.
You too. Thank you.
All right, let's continue.
Closed hearing. Do I get to hang up?
Yes.
I don't know how.
All right, so this is 2023-2641 DM, Trisha Rice versus James Rice. It is Monday, January 8th, 2024 at 1:36 p.m. Attorney Bendeley is filling in for Attorney Buckland for plaintiff Defendant is not here.
Ms. Bendelay, enlighten me, what's happening?
It's my understanding, Judge, I suppose if the court will recall, there was a scheduling conference on December 4th. Attorney Buckland had indicated he believed that he might be able to reach an agreement, or the parties might be able to reach an agreement. It was my understanding that they had in fact reached an agreement, which I was prepared to place on the record today. Obviously, the opposing party is not here. To that end, what I would just ask, I believe, is that the court sends the parties to mediation at this time.
Send the parties to mediation?
Yes, Your Honor.
Okay. Well, okay, what issues do you believe are in dispute?
Well, again, I had thought that there was an agreement based on Attorney Buckland's notes. So frankly, I don't think there is anything in dispute, but I was hoping that we could take proofs today, but obviously defendant's not present.
But we
so.
can take proofs regardless of the defendants here, so. Why don't we do this is,
Okay.
if there's no, I don't want to go through and do a whole scheduling order if you do have an agreement.
Right.
So why don't we take proofs, we'll reschedule it, we'll put a status conference for about 30 days and find out what's happening. And perhaps we'll have resolution by that time.
That works for me, Your Honor. And just for the court's reference, Attorney Buckland, I believe, was beginning to prepare a judgment of divorce, but he obviously doesn't have that for the court
Okay.
yet.
Ms. Rice, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Ms. Bendelay, you can proceed.
Thank you, Judge. Ms. Wright, throughout the course of this action, have you been working with Attorney Buckland to resolve the matter?
Yes.
And do you believe that you and Mr. Rice have reached an agreement as to the division of your property and the custody of your child?
Yeah.
Okay. As to real estate, is it true that there's no real estate to be divided among the parties, as the any real estate is owned by a third party trust?
Yes.
And is it also your understanding that each party would keep their respective bank account or credit union account in their respective name?
Yep.
And as to retirement, is it your understanding that each party would keep any respective retirement that they may have?
Yes.
As to life insurance, is it your understanding that each party would be awarded any life insurance policy that they are the owner of?
Yep.
And as to vehicles, is it your understanding that you would be awarded a 2016 Jeep Wrangler subject to any debt? You would also receive a 2014 Chevrolet Traverse, which will be signed over to your son.
It's already been signed over.
Okay, so the only thing that you would receive then would be that 2016 Wrangler?
Yep.
Okay, and then conversely, Mr. Rice would be awarded his Chevrolet truck?
Yep.
And to your knowledge, is there any other jointly titled vehicle that the two of you share?
No.
Okay. As to personal property, is it your understanding that each party would keep any respective personal property in his or her possession, subject to any debt, except that you would receive a China hutch, a Gravely zero-turn mower, your personal items, the kitchen table, and another hutch?
Yes.
Okay. As to debt, is it your understanding that each party would keep any debt in his or her respective name?
Yes.
And as to spousal support, is it your understanding that there would be no spousal support and spousal support would be forever barred?
Yes.
As to the custody, support, and parenting time of your child, can you please state for the court how old your child is?
He is 18.
Was he 18 at the filing of this action?
No.
Okay. Is it your understanding that the parties have agreed to joint legal and joint physical custody of the minor child, and that parenting time would be as the parents can mutually agree, taking into consideration the age of the child?
Yep.
And would it be also your understanding that this child support would be deviated to 0 given the age of the child and the timing under which he'd be under the court's jurisdiction?
Yeah.
And do you understand that we would have to include this because the child is still in high school?
Mm-hmm.
Okay. Do you wish to be restored to your maiden name or have the option to do so?
Yeah.
And could you state your maiden name for the record, please?
Salyer.
Okay. Could you spell that, please?
Salyer.
And at the filing of this divorce, were you a resident of the state of Michigan and of the county of Calhoun?
Yes.
And at the filing of this divorce, did you believe, or I suppose now, do you believe that there's been an irretrievable breakdown of the marital relationship such that the objects of matrimony cannot reasonably be reconciled? In other words, there's no hope of you getting back together.
Correct.
Are you currently pregnant?
No.
Okay. Do you believe that the agreement that we've placed on the record is a fair and equitable distribution of your marital property?
Yes.
Do you also believe that the custody arrangement that we placed on the record today is in the best interest of your son?
Yes.
Is there anything else that you would wish for the court to know at this time?
No, other than he keeps violating the PPO order.
Okay, I mean, as to the divorce at least, but
Yeah, no.
that resolves everything else.
Yes.
I have no further questions, Judge.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the approved judgment of divorce, UCSO, and other paperwork. You're not divorced until we actually sign that order, ma'am, so it still may take a few weeks to get all of that done. But at that point, best of luck to you. I hope everything works out for you. And you're free to go today. Have a good day.
Morning, Judge, or
Good
afternoon.
morning.
Please unmute Mr. Rice. Calling
Hello,
2023-2641 DM Trisha Rice versus James Rice. Today is Monday, February 12, 2024 at 1:40 p.m.
Court will note the appearance of Ms. Bendelay in this matter on behalf of the plaintiff. This is set for a status conference. When we were back in court on January 8, 2024, Mr. Buckland had stated he believed that they had settled this matter, and we were a bit stymied at that point because the defendant didn't appear. Ms. Bendelay, enlighten me, where are we at?
Yes, Your Honor. As the court noted, we had a scheduling conference on January 8th. Looks like Attorney Buckland had sent a judgment of divorce for review and signature to the parties on January 23rd. There was some subsequent email correspondence with Mr. Rice. I believe on February 5th, he had emailed essentially a counter proposal asking about a zero-turn mower or a wedding ring, which was declined. It's my understanding the parties have two mowers and Mr. Rice is getting one. My client was getting the other. On Friday, it looks like Mr. Buckland got an email from Mr. Rice about the judgment of divorce. It seemed that they had an agreement with the judgment of divorce. Mr. Rice indicated effectively that it better be as Mr. Buckland had explained, and that he would be in to go over exact items. My client did sign that judgment of divorce electronically today. It's waiting on signature from Mr. Rice. So at this point in time, it's really the only information I have. I'm not sure with Mr. Rice if he's planning on signing it or
Okay.
not.
Let me check. Mr. Rice, do we have an agreement and a settlement in this matter?
we can, but I want to make a giant statement first. Am I allowed a big statement?
No, this is a status conference. I'm just checking on what the status of the case is. Not a case to air any dirty laundry or make statements. Just a matter, do we have a settlement or do we not have a settlement?
Fine, consider my signatures.
Okay. So have you received from Mr. Buckland the judgment, sir?
I don't know. I really don't know. I paid little attention to. I don't know. Just
Okay.
consider it signed.
Okay, well, check your email and see if, again, it's signed.
I think this is the justice. She committed adultery. She
Okay, sir, again, I don't need a statement.
body.
Sir, I don't need a statement, okay? If you want to make a statement, go out in your backyard and yell at the wind, okay? Because at this point, I don't need to hear that. So, well, I will wait and see if we do have a resolution in this matter. If not, then the intent is
No child. I don't get any child support or nothing. She sold herself and sold out her family. But
Okay.
whatever. I
Okay.
signed. Consider the divorce signed.
Okay.
I'm not, I don't have enough gas money to drive over to sign the paper.
Your Honor,
Yes,
if I may
Mr. Blunt.
confirm Mr. Rice's email, to make sure we send it to the correct
I
place.
don't know how to email.
Oh, sir, because I see that we have some correspondence with you, and our staff at J. Is that the correct notice for you?
That's correct, but I don't know how to e-sign anything. I would have signed it 2 weeks ago if I knew how to e-sign.
Ms.
Are you-
I'm not
Bentley,
good
why
at
don't you send a paper copy? He can sign that and then return it to you.
I will do so, Your Honor. Thank you.
Okay, and then get the front of the court approval, and then we'll be able to, after the time runs, to be able to complete it.
Thank you, Judge.
Question,
Okay.
Judge,
Yes.
question.
Okay.
If I can find a ride and sign that today, will it be signed? Will you sign it off by Valentine's Day?
I will not, because the time frame is not run yet to do that. It's a 180-day waiting period, and today is only the 133 days. So by statute, I can't sign it until after the 180 days.
But what we can do, Mr. Rice, is get that sent in, and that way, once the 180 days comes up, then judge can sign it if it's on his desk before then. So we just need to make sure we get it to judge at that time frame.
She lived here a year.
Sir, it's 180 days from the date of filing, and that's statutory. I can't change that. So,
Mr. Rice, I'm sorry, Judge. Are you at the 6 Mile Road address still, Mr. Rice?
Yes.
Okay, thank you,
Okay.
sir.
We'll send that out and get it done, Miss Bendelay, if you would. When you do have that signed, let my office know, and then we won't have to schedule anything further.
Certainly. Thank you, Judge.
Okay, thank you. Court will end this matter at 1:45 p.m. You're free to go. Have a good day.
Thank you as well.